Hey everyone, it's Carol Williams with Williams Immigration, a boutique immigration law firm, and we are back with another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, y'all know I talk about H-1Bs most of the year, and so today is no different. But today we are doing part 2 of the new H-1B rule. That rule came out about 2 weeks ago now. It's over 400 pages, so I figured we would break this up because nobody wants to hear me talk about over 400 pages in one go. So, H-1B rule part 2. First thing I want to talk to you about is this rule talks about and really clarifies for us what is a specialty occupation. So when we talk about H's all the time, we're like, oh, it has to be a specialty occupation and it has to require a bachelor's degree. And then the individual that you want to hire has to have a related bachelor's degree. So we've been getting RFEs about what is specialty occupation, what degree is actually required. And so USCIS kind of bundled all of those together and has a section in there that really talks about what is specialty occupation. Oddly enough, it provides a flexibility in the definition, which I think is great. So it talks about what does normally mean? What does it mean when we say the job must normally require a bachelor's degree? So they've clarified that to say that the position doesn't always have to require a bachelor's degree. So there are some positions where a certificate may work. So they're really looking at now what does that word normally mean? And so they've come back and they've said, well, it doesn't always have to require a bachelor's degree. I think there's going to be a little bit of give and take on that over time. So I think we're going to see a few RFEs on that, but we're sort of moving in the right direction. They've also talked about someone has a qualifying degree that is directly related to the duties of the H-1B position. So it doesn't mean that there's only one degree that will work. There are some roles where different degrees will sort of get you to a position where you are able to hit the ground running on day one with a particular role. So, an example could be a job might require you might be able to do well in a job if you have a math degree or let's say a physics degree. So it's not just this one degree scenario any longer, as of the 17th, when this rule becomes effective. And they've also looked at directly related. So the phrase directly related. And again, it doesn't have to be just one degree that is directly related. Now we need to show that there's a, quote, logical connection between the required degree and the H-1B position duties. So again, this opens us up to a little bit more flexibility. Hopefully this flexibility will cut down on the RFEs because after all, really, the employer is in the best position to determine and tell USCIS what degrees it requires, right? Like what degrees are going to help an incoming employee do well in this role. So hopefully we'll see overall fewer RFEs because of this flexibility. I do think in the beginning we are going to see an uptick in RFEs as the adjudicators across the country and as the agency sort of comes to a decision as to how they're going to adjudicate these cases given this new regulation. So I think we're going to see sort of an immediate uptick in RFEs, but I'm hopeful that those RFEs will in fact go down as everybody sort of figures out how this is all working. Now, when we talk about specialty occupation, when you are placing an employee at a third-party work site, listen, the Immigration Service has been very loud and clear. They really don't like it when H-1B employees are placed at third-party work sites. But it is simply a fact of the matter when you are dealing, especially when you're working with a staffing company. So USCIS in this rule has also talked about what does the specialty occupation look like, and whose requirements are we really looking at when we're placing someone at a third party. So if we are placing someone at a third party that is not the actual petitioner, CIS is going to want to see the requirements of the staffing company's client, because that is where the work is being done. So really that just, it makes sense, right? So be prepared if you are placing one of your folks at a third party, that USCIS is going to want to see what that third party requires for that specific role. And does the person that you want to place at that third party meet your end client's requirements? That is going to be hugely important when we talk about staffing companies, when we talk about placing people off-site. And so I think we'll see more RFEs on this, because again, the CIS does not like staffing companies, y'all. So I think we're going to see more RFEs on this, especially when documents from the third party, from the end client, are not submitted in the initial application. The other thing that this rule talks about is, where does the employee fit within your third-party client, i.e., if you're a staffing company, you're placing someone at a work site. Where does this employee that you're placing at the work site, where do they fit into your end client hierarchy? Where do they fit in on that org chart? The rule essentially is saying that they have to be a part of that third company, and they can't just be there sort of willy-nilly performing a few services here and there. I suspect that we're going to see a ton of RFEs on this as the agency and the adjudicators figure this out. What does this look like? What does the agency want to see in terms of documentation and evidence? So again, I think we're going to see an uptick in RFEs as we're talking about what is specialty occupation, under this new rubric of this rule. But again, I think the flexibility over time is going to be super helpful for employers to really make their arguments to USCIS and say, these are our job duties. Here are the various degrees that we will accept. Here are the degrees that our end client will accept, if you're in a staffing company context. So next thing I want to talk about with the rule is, when does a change in work site require an amended H-1B application? So currently, when someone says this to me, my immediate response is, I don't know, let's dig a little bit deeper. Spoiler alert, even given this new rule, my response is going to be the same. However, now the Immigration Service has given us a little bit more to dig in with, and a little bit more context when we are trying to figure this out. So the rule really looks at when a company changes their work site, and whether or not that will then necessarily need and require an amended H-1B. And so we're looking at what was put in the LCA, what is the job location in the LCA, what is the intended area of employment. So is your job site moving to down the street or across town? Probably won't need a new amended application filed. Not a definite, but probably. Again, we'll go back and we'll look at the LCA. 3 towns over, possibly, if that's your new work site, it possibly will need one. 45 minutes away, probably going to need one. But again, depending on the intended employment area listed in the LCA, in some locations, those intended employment areas are fairly large. In some locations, those intended employment areas are very small geographically. So again, my answer is probably going to be, when someone comes to me and says, hey, we are switching locations, my answer is probably going to be, great, let's take a look. I cannot tell you sort of off the cuff. So given that my answers aren't going to change for now, I would encourage you, if you know that your office is changing locations, or you were thinking about moving an H-1B employee to a different work site than was originally listed in the application, please reach out to your immigration attorney before that change happens. So before you permanently change their work location, reach out to your immigration attorney so that you can have this conversation. Because telling us after the fact might be a little bit harder for us to help you get you where you need to be in terms of compliance with the rules. The next thing I want to talk about for this new H-1B rule, and again, the rule does not take effect until January 17th, but I want to make sure that y'all have this information before January 17th so that you can start sort of looking at what you're doing internally and if you need to make any changes. The new rule talks about really, is the job offered? Is it a real job, right? So they say, is it a bona fide H-1B employment? Really what that comes down to is a real job available? So the Immigration Service is now going to start asking for employment contracts, offer letters, and really any other documents that show that this is a real job offer. So I tell people, think about the new hire packet that you provide to all of your employees. Now, if you're a smaller company or maybe you don't have new hire packets, this is an excellent opportunity to standardize your onboarding for all of your employees, right? So immigration is going to start asking for these documents. So if this is something that your company is fairly light on in terms of an onboarding package and having some sort of standard process and standard set of documents, it's something that we want to look into. So keep that in mind. The new rule is really sort of turned off the itinerary requirement, really in favor of show us that this is a real job, right? Because many real jobs do not have itineraries. So that is a good thing. The new rule does add a requirement that the H-1B petitioner, i.e. the employer, must have a legal presence in the United States and a place where they can receive process of service. So that is, if someone decides to sue the company, where are they sending the lawsuit papers? It's just all that means, right? And so that has not particularly been a requirement or an ask of USCIS up to this point, but it will now be an ask under this new rule. And remember, this new rule requires a new form that will go into effect January 17th as well. So a lot of these new things that USCIS is asking for will most likely be on the new revised form. So just keep an eye out for that as well. So also, this new rule takes into account lengthy processing times, right? So the processing times are only getting longer and longer and longer. This new rule takes that into effect. So if you've ever been in a situation where you've filed an H-1B, let's say you've requested 1 year, just 1 year of H-1B status, but it takes over a year to process the application due to twists and turns. And honestly, those twists and turns could simply be long processing times and an RFE, and an application that potentially wasn't filed using premium processing. So when they actually adjudicate the application, it is past the time that you have requested in terms of validity dates. So if that's ever happened to you, it is not fun. And really what it means is that somewhere in there, you made a calculated strategy decision to file another H-1B application, right? With filing fees and all the things. So this new rule, again, will come into play January 17th. This new rule allows you to amend the validity dates if this happens. So what happens is, I'm guessing, USCIS will reach out to you, or we will be able to affirmatively reach out to USCIS and be like, hey, this hasn't been adjudicated, or hey, it's about to be adjudicated, but we're past the days that you wanted. They will allow us to amend those dates. In amending those dates, it means that we must file a new LCA. The employer must file a new LCA. If the wage has increased, the employer must now agree to pay the new wage. You cannot lower the wage. That is a no-go. So you must file a new LCA, ask for new dates. The new dates need to be covered under this new LCA. So this is incredibly flexible, and I think will really help several folks that opt not to process their applications using premium processing, and so that they now can change the validity dates that they had requested when USCIS processing times really sort of put them behind the 8 ball. So that's that. The next thing is, in this rule, the site visits. So site visits up until this rule, so really up until January 17th, when this rule becomes effective, site visits are a policy, right? So USCIS said, hey, we want to know what's happening on these sites. They send people out, they do site visits, right? Now, these site visits are part of the law. So as of January 17th, they'll be part of the law and no longer just policy. So that means if you as an employer opt not to be so cooperative during an H-1B site visit, USCIS can deny the application if it's currently pending, or they can move to revoke the approval. So now, again, is a great time to make sure that all of your compliance documents are in order. Site visits, so that you know, can take place at a previous work site, a current work site, or a future work site that is listed in the application. This also includes third-party work sites. So if you are a staffing company and you are sending people out to various work locations, your various end clients, USCIS can come to your headquarters of the staffing company, but they can also go to your client sites. So you want to make sure that your client sites are aware of that. So that is all I have today for part 2 of the H-1B rule. But the next thing I want to talk to y'all about this morning is still H-1B related. So over the weekend, we saw a flurry of activity on social media with respect to advisors to our incoming White House and them speaking favorably on the H-1B program, and not so favorably on some, on U.S. workers. So this has caused a bit of a social media back and forth. If the previous presidency of President Trump is any indication, this will not be the only back and forth that we will see on social media regarding immigration issues. It just, I looked at my crystal ball and it says it will not be the first and last back and forth that we see on social media. So we're not going to make any changes, right? Because the law is still what it is right now. We still have an H-1B program. We are still the Immigration Service is still processing 85,000 new H-1Bs each fiscal year. That is still part of the rule. We now have this new H-1B rule that will go into effect January 17th. So we're going to see what happens. We're going to see what the actual reality is when President Trump takes office in January 20th. But as of right now, nothing has changed. And again, I always say that social media is potentially a look into what an administration is thinking about. It is not a new rule. It is not a policy change. So far, no president has rolled out policy changes on social media. That could change. I don't know. If it does, I'll let you know. But there is a bit of a back and forth this weekend on social media about H1s. So we will keep looking into that. If something significant comes out of that back and forth, I will let you know. But as of right now, everything remains the same. And we'll talk soon. So have a wonderful rest of your Monday and a great rest of your week. And we'll be back again. Bye.